Hi, everyone. Thank you for joining us today for Constangy's webinar, Compliance Unveiled, 10 Must-Know Tips for the Pregnant Workers Fairness Act and Independent Contractor Rules. A couple of housekeeping items before we get started. If you have questions throughout the presentation, please submit them through the chat function. You can access the chat through the toolbar located at the bottom of your screen. Our presenter will leave time to answer your questions. This program is approved for Sherman HRCI credit. We will be sharing those codes at the end of this presentation, so please stick around in order to get the codes. Lastly, we will be providing a copy of the PowerPoint used during today's webinar and a recording of the presentation. These materials will be sent to you once the recording has been uploaded by tomorrow morning. I'm now going to turn it over to today's presenter, Brooke.
Thank you, Victoria. Hi, everyone. I'm Brooke Nixon. I'm a partner here at Constangy, Brooke, Smith & Prophete. I am in the Birmingham, Alabama office. I took a look at all of our registrants, and it looks like we have people from all over. So I'm excited to have you all here. I'm sure most of you guys know what Constangy, Brooke, Smith & Prophete does, but if you don't, if this is your first time here, we're a law firm that only does labor and employment law. So that's all I do every day, day in and day out is employment law. So I'm excited today to talk to you about two different topics, the Pregnant Workers Fairness Act and the new Independent Contractor Rules. I thought these were really timely topics where we have these effective dates that have either passed or are quickly approaching. And I'll be honest, I do not really hear my clients talking a lot about this. I don't know that I've really talked to many clients at all yet about the Pregnant Workers Fairness Act. And I think I should be, because I think that we definitely are going to see a major change in how we need to handle pregnant workers. And when I say workers, you're going to see that I mean employees and applicants. So there's a lot to talk about in the Pregnant Workers Fairness Act that will be becoming effective very soon. And then we have the new Independent Contractor Rules that are kind of go back to how they were a few years ago, but I think it's important for everybody to understand what our new rules are now, or what the current state of the rules are, and how the Department of Labor is going to look at them. So let's go ahead and get started. So first, we're going to talk about the Pregnant Workers Fairness Act, and we have to go back to what the law was, just a few years ago before we really started down this path of this new law. So there was a Supreme Court decision in 2015 that changed the state of the law prior to that. In 2015, there was a decision in Young versus UPS. And in that case, the court held that under Title VII, if an employer provides light duty to a large set of workers, or a large group of workers that were not pregnant, then light duty also needed to be provided to pregnant employees. Also, we learned in that case, and we knew before, that pregnant employees should be allowed to work as long as they can perform their jobs. You're going to see today that the Pregnant Workers Fairness Act kind of changes even that. Absent unusual circumstances, pregnancy alone is not considered a disability under the ADA. And unless that there's some kind of complication or something like that, then you just didn't really have to deal with the ADA. So prior to the passage of the Pregnant Workers Fairness Act, employers really had to only deal with Title VII and the ADA when that would come up. But with Title VII, like all other Title VII cases, the pregnant worker would have to show someone similarly situated who couldn't perform their job, but who were receiving some sort of accommodation or special treatment. You're going to see that the Pregnant Workers Fairness Act does not require any sort of similarly situated, employee at all. So Pregnant Workers Fairness Act, it was actually passed in an omnibus spending bill. And I think that's part of the reason why that not many people were paying attention to it. It wasn't a standalone bill. It was actually passed in December 2022. It was signed into law at the end of December. It went into effect June 27th, but we did not have any final regulations. So those final regulations just came out. So now we can really see how the EEOC is going to consider these claims by pregnant employees. So that was April 15th. The final regulation goes into effect on June 18th. So that is fastly approaching. So the Pregnant Workers Fairness Act requires a covered employee to provide reasonable accommodations. So there are, just like every other law that we have to deal with in the employment world, there's going to be certain terms that we have to see how they are defined by the law. So you've heard reasonable accommodation before. You've heard it with disabilities, and you've heard it with religion. Now you need to be thinking about that every time you have a pregnant worker. So the Pregnant Workers Fairness Act requires a covered employer, we're going to define that, to provide a reasonable accommodation to a qualified employee's known limitations relating to pregnancy, childbirth, and related conditions. We've got to have definitions for pregnancy, childbirth, related medical conditions. Also, accommodations are required unless there would be an undue hardship. So what's the definition of undue hardship? So we've got to get into all of those definitions. So employers are only required to make accommodations for known limitations. Well, known, what does that mean? It means the employee or their representative has to communicate what those limitations are to you. You don't have to guess, you don't have to, and you shouldn't go to an employee and ask them. They should make those limitations known to you. So a limitation under this law means a physical or mental condition related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions. You're going to see that any sort of condition, even if it's a minor condition, even if it's episodic and doesn't happen all the time, would still be considered a limitation under this law. Also, a need or a problem relating to maintaining the employee's health or health of the pregnancy and seeking health care. So not just the conditions, but you're going to see that on the list of accommodations that it's also going to affect your employees asking for time off when they need to go to the doctor, things like that. Also, it's important to understand that the definition of pregnancy is actually more, it's broader than you might think. It includes current pregnancy, it includes past pregnancy, it includes potential or intended pregnancy, meaning infertility or fertility treatments. It is a definition that the law says it's not even exhaustive. They said anything that an employee could argue is pregnancy or related condition, then it's likely to be considered covered under this law. So what can employers do or not do? Okay, they cannot require an employee to accept an accommodation other than a reasonable accommodation arrived at through the interactive process. Everybody on this call, I'm sure, has gone through the interactive process for disability claims, but you probably don't have to do them that often. Well, now think about your employees and how many employees that you have that could fit into this box. You have your employees who possibly have a disability, and now you have this much larger group of potential workers who are going to require the interactive process. So just like with the ADA, you have to go through that interactive process and discuss what would be a reasonable accommodation. You cannot deny employment opportunities based on the need for you to make a reasonable accommodation. As I mentioned previously, this law applies to applicants. So you cannot, decide not to hire someone because of their need for an accommodation once they're employed by you. You cannot require a qualified employee to take leave, whether paid or unpaid, if another reasonable accommodation can be provided. I know that I've had many clients who, when they have a pregnant employee that has limitations, their first instinct is, well, I'm concerned about their safety. I'd rather them just stay off of work until they're able to perform this job. Well, Pregnant Workers Fairness Act says that you cannot require them to take any sort of leave if some other reasonable accommodation could be provided. You cannot take adverse action in terms of conditions, in terms of employment, conditions of employment, or privileges of employment. You've heard of that in Title VII and are probably familiar with it. I would say that this next slide was, as I was preparing, I thought that this was probably one of the most important. And, you know, I try, of course, not to read off slides, but I think that we need to really sit here and look and consider your employees and the type of things that they may ask you for, and that this law specifically lists these things as possible reasonable accommodations. The law doesn't say, or the regulations don't have an exhaustive list. There may be other things that your employee asks for that you may have to provide to them. But this list right here are in the regulations. So an employee may ask for additional longer or more flexible breaks to drink water, eat, rest, or use the restroom. I figure most of my clients are not going to have any issues with that. Changing food or drink policies to allow for a water bottle or time to eat. That's probably going to be fairly simple as well. Changing equipment, devices, or workstations, such as providing a stool to sit on or a way to do work while standing. Now, I'm sure that, you know, depending on what type of work your employees do, I've definitely had clients have called me and said, you know, our policy is that employees have to stand when they're doing this. I have a disabled worker who's asking me if they can sit. I don't want them to sit because the policy is that I want everybody to stand, but under the ADA, an accommodation may need to be that they need to sit. Now you have that same sort of concern with a pregnant employee who says they don't want to stand doing their job, they need to sit, and the regulation says that would be a reasonable accommodation. Changing a uniform or a dress code or providing safety equipment that fits. Here's one that I was very interested in. Leave to recover from childbirth or other medical conditions related to pregnancy. So what does that sound like? That sounds like the FMLA, right? But the FMLA, as we'll talk about in a few minutes, just to remind us, there are certain requirements that an employee has to meet before they're entitled to FMLA leave, right? Well, Pregnant Workers Fairness Act does not have those same sort of requirements. Changing a work schedule, such as allowing shorter hours, part-time hours, come to work at a later time, maybe because the employee is having morning sickness, telework, temporary reassignment to some other job. Here's a very interesting one. Temporary suspension of one or more essential functions. So you guys know that under the ADA, an employee has to be able to do the essential functions of a job with or without a reasonable accommodation. The Pregnant Workers Fairness Act says that a reasonable accommodation could be that they're not required to perform the essential function at all. Leave for health care appointments. And then, of course, light duty or help with lifting or other manual labor. So the actual definition of reasonable accommodation in this law is the exact same definition under the ADA. However, these regulations did provide us a list of possible reasonable accommodations, and these are on it. So, of course, like any of our laws that we have in the employment arena, there's going to be a no retaliation provision in there. The Pregnant Workers Fairness Act prohibits retaliation because an employee has opposed an act or because the employee made an EEOC charge arguing that they were discriminated against. Employers, of course, cannot coerce or intimidate or threaten you know, any individual who's trying to obtain their rights under the Pregnant Workers Fairness Act. All right, let's get into who on this call is going to have to worry about this. Well, so the Pregnant Workers Fairness Act says that we're going to apply to all covered employers. What's a covered employer? A covered employer is one who has at least 15 employees. It includes private employers, public employers. It even includes Congress. A lot of times Congress exempts themselves out of it, but it includes Congress, all federal agencies, employment agencies, labor organizations. It's a very broad definition. And it applies to qualified employees, which include current employees of your workforce and also applicants. So what is a qualified employee? this is definitely a new situation that you're going to have to deal with on a qualified employee. So qualified employees under the Pregnant Workers Fairness Act are those who can perform the essential functions of their job with or without reasonable accommodation. So that's the same as, the ADA. So that's the same. But then it also includes employees or applicants whose inability to perform that essential function is either temporary or you could accommodate it. Okay, temporary meaning that they would be able to do it in the future. So that's this next bullet point here. It says that a qualified employee or applicant would be a person whose essential job function could be performed in the near future. What does near future mean? Near future essentially means 40 weeks. So it essentially means, could this person perform the essential functions after they were no longer pregnant or after they were no longer experiencing this condition up to the time period of after they've had a child? So I want you to think about the sort of situations that you may have when this is the definition of qualified employee. You have an applicant that comes that applies for a job and they're pregnant, and you know that part of their job is going to be lifting or whatever it is that they're telling you that they're not going to be able to do until after they have their child and after they come back from work. And they would have rights. I'm not saying that your decision one way or the other would absolutely violate the Pregnant Workers Fairness Act, but they would have rights under the Pregnant Workers Fairness Act. If you did not hire them because they were not going to be able to do the job, then they could possibly have a claim and file an EEOC charge under the Pregnant Workers Fairness Act. So, and as I was just mentioning, that's what would have to happen here. So employees and applicants can bring a private right of action against their employer after exhausting their administrative remedies through the EEOC. Actually, the EEOC began accepting charges of discrimination based on this act in June of last year. We don't have any data on whether and how many charges were actually filed under the Pregnant Workers Fairness Act since June 2023. But we do know that pregnancy-based charges generally are on the rise. There were, there were almost 3,000 charges in 2023 versus 2,200 charges in 2022. So they are on the rise, absolutely. And out of those, the EEOC found that the employer likely violated the law in 716 of those pregnancy-based charges. So now we just know that there's likely to be even more because we have this new area that employers did not have to deal with before. You have the accommodations process for pregnant employees. All right, so what are the damages? What exposure do you have? Well, relief under the Pregnant Workers Fairness Act would be the same for private employers, would be the same as under Title VII. So they could possibly ask for reinstatement or to be hired. They could ask for back pay. They could ask for front pay, compensatory damages, punitive damages, and attorney's fees and costs. So when you're considering, what is your possible relief that an employee could get in a Title VII case, same thing for the Pregnant Workers Fairness Act. All right, and similarly, you do have an affirmative defense if you can demonstrate that you took good faith efforts in consultation with the employee during that interactive process to identify and make a reasonable accommodation. And you do have the option of arguing that the accommodation that the employee requested would be an undue hardship. So we will talk about that in a few moments as well. So I want to just briefly, now that we kind of talked about what the new rule is, very briefly discuss some of the old rules. So now that you know the new rule, you can see how they differ so that you can be picturing in your mind, how is my life really going to change? How is my HR department really going to change? So the Pregnancy Discrimination Act actually just amended Title VII to add to add that pregnancy is also included in the word gender. So that happened in 1978, and it prohibited discrimination. So when you're talking about discrimination, you're talking about treating a pregnant worker differently than treating a non-pregnant worker. So that law prohibited discrimination, on hiring, pay, job assignments, promotions, training, things like that. Then, of course, you have the Americans with Disabilities Act. And the Americans with Disabilities Act did not always, or even often, come into play with your pregnant employees, because generally a normal pregnancy without complications did not rise to the level of a disability. Therefore, you did not have to go through the interactive process. You did not have to, you just didn't have to deal with accommodations at all under the ADA for pregnant workers. FMLA. So with the FMLA, depending if your employee had worked for you for a year and had the requisite amount of hours, then you may have to provide FMLA leave for the birth or adoption of a child. So it includes certain employers, which is a higher level than the 15 that we have for the Pregnant Workers Fairness Act, right? It just requires, I'm sure most of you are familiar with the FMLA, and now that you've heard that the Pregnant Workers Fairness Act does not require employees to have worked for you for a year, does not require for them to have worked for you any particular hours, you can see how the sort of things that you were able to deny for newer employees, you may not be able to do anymore, because the EEOC has said that reasonable accommodations for a pregnant employee would be leave to allow them to go seek health care. That's something that you may not have done under the FMLA if they were not entitled to FMLA leave. So under the Pregnant Workers Fairness Act, a pregnancy related medical restriction does not have to rise to the level of a disability. We don't even go through the disability analysis. The duty to accommodate a pregnant employee is not going to be dependent on whether the employer accommodates other employees. This new law is going to go, beyond a lot of the other laws that you've had in the past because of the expansive nature, it including applicants, it including people who can't even perform the essential functions right now, even with an accommodation, because as long as they could perform them in the future, the near future, after their pregnancy is over, then they could still have rights under the Pregnant Workers Fairness Act. I do want to mention, because I know that we have a lot of people on this call that are from different states, that the Pregnant Workers Fairness Act is the floor. Okay, so there are lots of laws. When I last looked this up, it said that there were at least 30 states who had additional laws. Here in Alabama, we do not have any other laws that protects pregnant workers other than the federal laws. There are at least 30, it said 30 states and or cities, so maybe not 30 states, but there are, I'm sure, plenty of people on this call that already have some form of protection for pregnant employees. So this is the floor. So even when you're looking at your other state laws, if this adds to it in any way, you still have to comply with this. You're going to comply with your state law, but then if the Pregnant Workers Fairness Act gives any additional rights or puts on any additional obligations to you, then you're going to have to comply with this. And, employers are going to have to change their strategy for addressing pregnant employees. So I just wanted to give a quick example. The EEOC, if there was an EEOC charge filed, for example, by a certified nursing assistant, at a nursing home in 2022, if they alleged, if they filed an EEOC charge and they said, hey, I was pregnant and my employer forced me to take leave, I did not want to, I'm not sure that they would have had much of a claim, barring some other circumstances, but they wouldn't have much of a claim because employers were not required to allow you to continue working and go through this process to figure out if you had if there was some sort of accommodation that they could do to allow you to perform different work, they could just say, hey, we don't have anything for you to do, so we're going to require you to take leave until you come back. Well, now, under this new law, they may have rights. They may argue that you were required to go through that process and try to figure out, was there something else that this employee could continue doing at work as an accommodation until the restrictions were lifted. Before I get to this, just real quick, I wanted to mention undue hardship. I didn't have a whole slide on it. I thought I did, but undue hardship is the same, is defined the same way as it is in the ADA. And so, you know, you'd have to argue that providing the accommodation that the employee requested, or providing any accommodation, if you're going to argue that there's no accommodation, you would have to argue that it would be an undue hardship. And I'll just tell you that for my clients, when they want to argue undue hardship, I discuss that extensively with them, because especially if you're going to argue that, you know, money would be an issue, then you go to court about it, and essentially your company's finances are going to be in play. The larger your company is, the harder it's going to be for you to argue that it would be an undue hardship. The more employees that you have in this or in that pregnant employee's position in their title, the harder it's going to be for you to argue that it was an undue hardship for you to let this person do what they want to do. And if this person is the only employee who comes in at 7 a.m. and they're the ones who opens the door, gets everything set up, and you need them to continue doing that, and this pregnant employee says, I can't come to work at 7 a.m. in the morning anymore, I have morning sickness, I need to not get in until 9, your argument may be, well, it would be an undue hardship for us because she's the person who comes in at 7 a.m. and that's her role. Well, the court's going to want to know, do you have somebody else that could do this just for this temporary time? You've got to really, really think through undue hardship analysis if that's the route that you're going to go. So the title of this presentation was called 10 tips. So at the end of each of our topics, I've got 5 tips for you, and they're broad and they're big and they're lots of work for you. But I think this is what you need to leave from here, knowing that you need to go do. Number 1, you've got to be starting to think now, given what my employees do, all of them, every position you can think of, given what my employees do, what type of accommodations am I going to be asked about? You can just think about, you know, if I was a pregnant employee, what would I be asking for? And go ahead and think through scenarios and try to figure out how you're going to handle them, because you're not going to need to spend an extensive amount of time figuring out this interactive process and figuring out if you can say yes or no, because you got a pregnant employee there that's asking for an accommodation. You can't wait a month before you get back to them. So I think you need to go ahead and start thinking about it now. You've got to train your management and your HR staff, and you've really got to talk to your frontline managers so that they do not blow off requests that previously they might have. So you got a pregnant employee that comes up and says, I've got to have a longer break. I can't get back to work in 10 minutes. I need 20. And you've got your frontline managers have to know when they need to handle that and deal and possibly go to HR about it. You need to review your current policies. I've got many clients that have policies about light duty and accommodations, and the whole reasonable accommodation language and all of that are only found in the ADA policies. Now you've got to put it in for your pregnant workers. Engage in the interactive process. So if anybody starting in June, if you've got a pregnant employee or not even a pregnant employee, remember it also includes fertility treatments and past pregnancy. So you have any employee that's essentially asking you for something, some special treatment, that's what I would probably call it, some special treatment for them because of their pregnancy or childbirth related condition, you've got to know, I've got to engage in this interactive process. And then just like everything, I'm a lawyer and I cannot, leave you without telling you to document everything. You've got to document everything, every request they make, every response that you have back. Like you've got to do that. There's one area that I really wasn't able to get into today because because we've got this other topic really to do, and it's about documentation. from doctors. And I know that some of you probably have questions about that. There are very limited circumstances that you can ask for medical records about any of this. So before you ask for anything, definitely talk to your legal counsel about it. The regulations explain the circumstances under which that you could ask for medical documentation, but it's rare. It's really rare. So let's see. Before I move on, I'm just going to take a quick look and see if there's any questions that I could address quickly. And I will just say that if I can't address your question, then I will get back to you by email. So I see somebody has a very specific question. So I will try to get back to that. Some of them it looks like that I may have answered. Like one question was, what is the difference between this law and the Pregnancy Discrimination Act? So hopefully I've addressed that. This is a good question. Can you require an employee to first use up sick leave hours and then grant additional leave? I don't know that I've read anything specifically about that, but generally in all of these laws, if you're going to allow some sort of leave or some sort of time off, I would say across the board, employers are allowed to require employees to use whatever policy, whatever leave time that they have available under their policies first. So absolutely, you should be able to do that. Let's see. Okay, so can you touch on the overlap between this new law and the Pump Act? And do this new law protections extend to lactation accommodations? They absolutely do. So lactation was actually included in this whole broad list of what is a pregnancy or childbirth related condition. It is included with that. So this says, if you complied with the Pump Act, have you fulfilled your duties for lactation accommodations? I'm not sure about that. I am certain that there is going to be a plaintiff's lawyer who says, even if you've complied with the Pump Act, you're required to go through this interactive process. And if an employee asks you for something that is not required by the Pump Act, the court will still look to see if you've complied with the Pregnant Workers Fairness Act. So let's see. It says, does the act define the amount of time employers must allow for pregnant workers to take leave? Like, is it 12 weeks like FMLA? I don't think that's defined. So I think it's going to be reasonable. I don't think that every time that a court is going to require 12 weeks, I think it's going to be more of probably a case-by-case basis. But absolutely, courts will say, well, 12 weeks is what we've decided for the FMLA. If you gave 12 weeks, that would probably be considered reasonable if you were doing, up to 12 weeks. Does the Pregnant Workers Fairness Act cover postpartum depression? Yes. Yes, it does. I believe that's specifically mentioned in an example or something like that in the regulations. Could you run leave under this law concurrent with FMLA? I think so. I think so. I think this is really meant, and I think I even read this that when Congress was describing it, they say they want this to fill in the gaps for the workers who are not protected by these other laws. So if they're protected by FMLA and you want to say, well, we're going to give you leave under the Pregnant Workers Fairness Act, those can be concurrent. That's fine. Let's see what else. The kind of same question. If an employee does not have FMLA but has personal leave available, can we make it run concurrently? I think you can make anything run concurrently. So did have a question on, can you require a doctor's certificate for a leave of absence? So one thing that I read in the regulations and just the commentary about this from Congress was that if you only require a doctor's note from someone who takes leave, if someone's out of work for 3 days, you can't all of a sudden just decide if your pregnant employee wants to go to the doctor one time or needs to be out one time for their pregnancy related condition or one day. You cannot require a doctor's note for that if you're only requiring your other employees to provide a doctor's note if they're out for 3 days. So that's one thing I read. Just generally, you need to be careful about requiring doctor's notes. Do they need proof that they're pregnant? Probably not, because this is not just for pregnant employees. This is for any related condition. They would need to tell you what the reason is, just like for under the ADA, where an employee can't just say, hey, I'm disabled, I need to sit on a stool while I'm working. they have to explain to you what their disability is, which requires them, or they're asking for, to be able to sit on a stool. Similar situation here. They need to let you know what the condition is so that you can determine if the condition and the accommodation, connect and relate to each other. Any retroactive effect? No, I don't believe so. What are they saying about remote work or work from home when it's not a work from home position? That's going to be difficult. And there, I think you're going to get into the undue hardship argument. And I think that you're just going to have to think about what's reasonable. When my clients are trying to make these decisions, I try to tell them, if you're standing in front of a judge, yourself, and you're having to explain to the judge why you told this person they cannot work from home, would it sound reasonable? Because previously, before COVID, I'm sure a lot of employers said, there's no way this work can be done from home. But now a lot of us see this work can be done from home. So just think about what would be reasonable. Could you just have a question to the doctor to ask what accommodations are needed? Very limited circumstances, sort of like the ADA. If it sounds like the condition that they're telling you about and the accommodation they're asking are not reasonably related, you could ask for a doctor's note explaining what accommodations that they need. All right, so I'm gonna go ahead. There was a lot of questions, so I'm gonna go ahead and move on to our next set of our next topic. And then if I can get back to those, I will. If not, I will try to address them to you by email. Okay, so this one probably not as exciting to you, but you have to stay here so that you can get your SHRM credit and things like that. You got to get your numbers at the end. But I think you should pay attention to this one too. I really do. There is a change for these independent contractor rules. It does essentially go back to the state of the law prior to the most recent rule. So we're going to go through that. The rule was one way, and then they changed it during the Trump administration, and now we're kind of back to the old rule. But I'm going to explain all of that. So Fair Labor Standards Act definitions, what is an employer and what is an employee, and who is included in the protections of the Fair Labor Standards Act. It's very broad, but the Fair Labor Standards Act does not define the word independent contractor. It's not in that law. So we've spent all of this time, decades, trying to determine who's an independent contractor and who's an employee. And the analysis for that determination has changed over time. So the FLSA definition of employee, what does it mean to employ a person, was designed to broadly cover as many employees as possible. But early on, our court said that independent contractors would not be covered under the FLSA. They would not be required to be paid overtime and minimum wage and keep track of their hours and all of that. So I don't know how many on this call, have had to deal with a Department of Labor audit where the Department of Labor has come in and said, we do not believe that certain of your employees should have been listed as independent contractors. You should have had them as employees. You did not pay for their employment taxes, and you should have, and now here's your penalty. So employers cannot misclassify a worker even if the worker agrees. So I've had lots of clients call me and say, my company and this person, we're in total agreement that they want to be an independent contractor. They want to be paid by 1099. They do not want taxes cut out of their pay. Doesn't matter if the worker agrees. It doesn't matter if you have an independent contractor agreement. It doesn't matter if you have a contract that says all of the right things. Just because you pay them in a 1099 does not mean that the Department of Labor is going to agree with you. Whether you're paying them in cash or check does not matter. Common industry practice. I've got a lot of clients who tell me this is how it is done in my industry, and if I have to do it different, I'll be out of this industry. And I'll be honest, last time somebody told me that, I said, well, you're the one in front of the Department of Labor right now. So if you are aggravated that your competitors are still able to do this, then I don't know, I guess you need to turn them in. You need to send an anonymous complaint about them to the Department of Labor, because you're the one who has to answer for this now. Saying that everybody in my industry does it this way is not going to help you. Having an employee identification number, or that the person has their own LLC, that's not going to take care of it either. Any of these things on their own is not going to take care of it. So we really started long ago trying to figure out whether a person was an employer, an independent contractor, using this thing called the economic realities test. From 1947, the Supreme Court said there's 5 factors that we're going to look at. No one factor is controlling. The list of factors is not exhaustive. We could look at other factors. It's very open-ended. What this factor test does is try to determine whether the worker is economically dependent on the employer, and if they are, they're an employee, or if they're in business for themselves, then they're an independent contractor. So since that decision in 1947, courts have applied, and the Department of Labor has issued regulations on the factors and how they're supposed to be, looked at, how they're supposed to be considered. Well, in 2021, we have, during the Trump administration, a change. Some people thought it was a drastic change. Some people thought it was not very drastic, but in reality, it was more business friendly, because the 2021 rule said, we're going to look at 2 core factors. We're going to look at the nature and degree of control over the work, meaning you as the employer, how much control do you have over this person's work? And we're going to look at the worker's opportunity for profit or loss based on their initiative or their investment. And what these regulations did in 2021 is said, if both of those factors tell us that the person is an employee, then we're really not even going to look at the other factors. If both of those factors tell us that this person's an independent contractor, we're not going to look at those other factors. So it was more business friendly in a way, because businesses could look at these 2 factors, try to get them right, and ignore the rest. Okay, so the other factors, they've really been the same all along: the amount of skill required for the work, the degree of permanence of the working relationship, and whether the work is integral to the employer's business. Those are the other factors that under the 2021 rules, the court said, we won't even really look at them unless the first 2 factors are going in different directions. Well, what are we doing now? We're essentially going back to how it was previously. So on October 13th, 2022, the Department of Labor issued a proposed new rule on the independent contractor classification. 2024 in January, they issued the final rule. And essentially what this rule does is say, forget about 2021 rule. There's no situation where we're only going to look at these 2 factors. We're going to look at all the factors. Other places or other courts might call it the totality of the circumstances. We're going to look at everything, and we're going to make our own decision about whether this person is an employee or an independent contractor. The final rule was effective on March 11th. There have been legal challenges to the rule, but it really is going back to how the rule was previously. So we're going to go over a few of these just as a reminder, because what I've found is a lot of clients set up their workers as employees or independent contractors. They do it when they first start their business. The HR department, they've had it this way for a long time, and they really never consider, they never look at it again and try to decide, hey, if the Department of Labor came to audit me, do I have everybody in the right place? So opportunity for profit or loss. The relevant considerations are, whether the worker determines or can negotiate the pay for the services, whether the worker is able to accept or decline jobs, or do they have to take every job that's given to them? Whether the worker engages in marketing and advertising to expand their business or secure more work, whether the worker actually uses their managerial skill to hire people and fire people and things like that. So, the more opportunity that they have to determine how much money they make on each job is going to be more likely that a court says, okay, that's an independent contractor and not an employee. All right, investments by the worker and the employer. So, does the worker have to provide, their own equipment? Do they have to pay for their own expenses? Things like that. So we're not actually looking at dollar, what is the employer having to provide and what is the worker having to provide? You're really just looking on, is the worker actually making an investment into the job that they're doing, or really are they just going to do a job that the employer is providing everything for? The degree of permanence of a relationship. So I've actually had experiences with some clients that had Department of Labor audits, and I've really gotten in arguments over this one and one other that I'll get to. But the degree of permanence of the relationship is, I feel like that it's a problem when you have a worker who maybe, let's just say, for example, because I've had a similar situation where you had somebody who's retired and they really are only kind of doing this work for this company kind of on the side, but they only do the work for this one company and they do it for years. So why does that factor have to, lend the Department of Labor into deciding that this person is an employee instead of an independent contractor? But that's what these regulations do. They say if there is some sort of permanent relationship, you've had this person working in or doing this job for a long period of time, and they really do it just for you, then the Department of Labor is going to say this factor supports a finding that the person is an employee. Now, does that mean that we're going to find that they're an employee? No, they got to look at the other factors. But this factor, if there was a permanent sort of relationship, then this would be a factor in deciding that the person was an employee. The nature and degree of control, I think this is what most of us think about, and this is what most of my clients are focused on. They think, well, let me just make sure that they're the ones making the decision about their schedule, and they're the ones who get to decide when and how they do the work. And they really focus on this one, which is good. I want you to focus on some of them, because we need to get, for my clients, when you're trying to argue that they're an independent contractor, I need every factor that I can get on the side of an independent contractor. But I just, wanted to bring all of these up because there are other factors. So the integral part of the business, this one's difficult. So I had a retired veterinarian. I had a veterinarian clinic that I represented. They had a retired veterinarian who did vet work when the main vet was on vacation. So rarely did it happen, but that's what it is. So a retired veterinarian, he only came in when the vet was out of town, but he did it every time he was out of town. If the main vet was sick, then he would come in and do the work. If the main vet went out of town for 2 weeks, he would come in and do the work. And he was a retired vet, so he only did it for this one company, this one veterinarian practice. Well, the Department of Labor came in and said, this person is an employee. You can call them a part-time employee, you can call them whatever you want, but they're an employee because they are doing the work that this company is set up to do. This is a veterinarian office, and that person is doing veterinarian work. Therefore, it is an integral part of their business, and this person is an employee. And so the other factors that got my client was the fact that the retired vet didn't have any of his own equipment. No, he doesn't have his own x-ray machines and things like that. He's using theirs. Also the degree of permanence. So you can see how certain situations, the factors are just going to not be on your side. So you've got to take a look at every single person that you have in an independent contractor classification and consider these factors. Skill initiative, that's been one for a long time, whether the worker uses specialized skill. That was my argument. This is a veterinarian. No one's telling them what to do. They are using their own skill, high level skills and education to make their own decisions. But the Department of Labor said, no, these other factors are, weigh, in favor of this person being an employee. So your 5 tips for compliance for this area is to review your workforce. If we hadn't had any changes in the law, maybe you aren't at such a, maybe it's not time, or maybe you don't have to be so concerned. to consider all of this, but because there are changes in the law, because we are going from one set of regulations to another, I think that we're going to see more audits. And you can see that here, number 4. We expect an increase in on-site audits. It's specifically for targeted industries, and you can find whether your industry is a targeted industry. Usually the Department of Labor puts out something showing, the industries that they're going to focus on. But so that's why we say that you should review your workforce. You should look at every single person in your workforce that is paid by 1099 or in some other way you've classified them as an independent contractor, and decide whether you have, the factors on your side. There are law firms, including mine, who will do essentially an independent contractor analysis and determine whether we believe that you have your employees in the right, in the right category. Consider and review all of your independent contractor agreements. So once you've decided, yes, these people are independent contractors, do you actually have agreements for them? Because that's the first thing that I want to show the Department of Labor, is that there is an independent contractor agreement, contract in place. Review benefit plans and tax filings and making sure that you're compliant. For example, there's some healthcare, situations, there's some healthcare industries that you cannot cover, healthcare for independent contractors. You can only cover for employees. So do you have somebody that you're calling an independent contractor, but you're paying for their health insurance? So that's something that you need to consider. Prepare for increased audits, and just consider any state laws that may have additional requirements for independent contractors. All right, I'm going to take a look at, let's see. Okay, so one of these questions are for number 5, the integral part. That's the one I always get hung up on. What if the contractor does this sort of work for multiple employees? For example, a friend has a business consultancy, and she uses a collective of business consultants for her projects. They have full-time jobs or other clients outside of her, but repetitively work on projects for her. What I say every time about this is we've got to look at all the factors. When I am representing a client in an independent contractor argument, I get out the factors and I try to show that, there are more factors on my side, because there are certain situations where there's nothing that I can do to change some of the factors. For example, with my veterinarian office, I could not change that factor about, utilizing their own equipment. I mean, he's not going to bring in his own equipment to work on animals. So there was nothing that I can do about that. When, that slide that talked about investment of the worker and, are they using their own equipment and tools? Well, okay, that factor is going to be on the employee side. So I've got to get as many factors on my side. But there are certain situations where I just think that the factors don't really work, where you have someone that's retired and that's all they're doing. And they just consistently do one thing for one employer, because when you're looking at whether that person is economically dependent on that employer, well, what if the retired person has retirement income and they have savings? So they're not really dependent on that employer for their livelihood, but that is the only employer that they work for. So for your question on this, business consultants, you got a lot of facts in there, so I'll take a look at it and see if I can answer more closely or more specifically. But I would just say generally, we've just got to look at all the factors. Somebody asked, what are the requirements involved in being a joint employer? That would be a whole presentation for me to argue about that, or to explain about that. But I will say that for joint employers, as long as when you have somebody who's working for you, or doing work for you, but they're coming from a staff agency, or they're doing work for you and they're also doing work for someone else. What I tell my clients is that number one, they probably need to be an employee of someone, especially if it's a staffing agency situation. Need to be an employee of someone. Shouldn't be an independent contractor for everybody if it's for a staffing agency. But if it's somebody who's working for a lot of different people, then maybe that helps you on the factors in arguing that they are actually an independent contractor. But for concerns of liability. So for example, like discrimination or harassment and things like that, I always tell my clients, assume that you're going to be considered a joint employer for liability to concerns. Do not think that you are going to make this person an independent contractor and you're going to get rid of all liability associated with them, but because you're not. So let's see. All right, 12:55. That went by really fast. So I've got a lot of questions in here. Hopefully I can get back to you. If I don't get back to you, please, email me. I need to get to these other slides for you so that you can have your credit for those. On the last slide that I put up in a few moments, it will have my contact information. Please reach out to me. I will say that when they send you the link to this presentation or the slides, however they're doing it, there are notes at the bottom of the slides. It has examples, a lot of things that I couldn't get to. One thing that I think is helpful is on all of these independent contractor slides, all of the factors, it has some examples at the bottom, like this person would have been an employee, this person would have been an independent contractor. So I think that can help you get some actual examples. It says if a nurse has this situation, that's going to lead this factor more towards independent contractor. If a nurse has this situation, that's going to lead for the Department of Labor to consider that person as an employee. So thank you so much. Thank you for everything. Thank you for being here. Thank you for taking time out of your day, asking questions. And I hope that I can work with some of you guys about that. Okay. Thank you.